Good afternoon, everyone. My name is Evan Champa. I'm with the law firm of Holland & Hart. And here we're going to be talking about waters of the United States, as well as critical management areas in Nevada, specifically focusing on Diamond Valley. By way of background, I have my degree in hydrogeology from the Mackey School of Mines, spent 4 years working as a consultant before switching over and going to law school. So without further ado, here's a little bit about waters of the United States. Here's some broad key terms associated with waters of the United States. WOTUS, SCOTUS, POTUS, the EPA, Clean Water Act, or the Act, a permit, which is required in certain circumstances, as well as Maui, the Supreme Court's most recent decision regarding waters of the United States and permits under the Act. So the Act, Congress prohibits, and you'll notice that there are some bold and italicized words here, the discharge of a pollutant from point source to navigable waters of the U.S. unless there's a permit. So the discharge of a pollutant is the addition of any pollutant to navigable waters from any point source. So a pollutant, it's kind of broad. There's a lot of things associated with what a pollutant is, and you could read that, that's fine. Navigable waters, they are waters of the United States, including the territorial seas. But what are waters of the United States? This is something that's not defined under the Act, so it's open to interpretation. And then a point source. Any discernible, confined, and discrete conveyance, including but not limited to any pipe, ditch, channel, tunnel, conduit, well, discrete fissure, container, rolling stock, concentrated animal feeding operation, or vessel or other floating craft from which pollutants are or may be discharged. So the Supreme Court of the United States got presented with a question on whether groundwater discharge requires a permit under the Act. There were a few court decisions below with the different appellate courts, which were kind of all over the board. The Ninth Circuit in particular said that a permit's required is something that's fairly traceable and more than de minimis, or more than just a little bit. The Fourth Circuit said if there's a groundwater discharge within 1,000 feet of water of the United States, then a permit's required. And the Sixth Circuit said it's groundwater. It doesn't apply at all. So the key issue, whether a discharge of a pollutant from a point source that travels through groundwater to a water of the United States is the functional equivalent of a direct discharge from a point source to a water of the United States. Well, the court said it depends. Have to judge it on a case-by-case basis. In the court case in Maui, they said a permit is required for discharge of pollutants from a point source that reaches navigable waters after traveling through groundwater if that discharge is the functional equivalent of a direct discharge from the point source into navigable waters. Well, how do you define functional equivalent? The functional equivalency test is right here. The court said, in order to determine whether a permit is required for groundwater discharge into a water of the United States, you need to look at the transit time, distance traveled, nature of the material, extent the pollutants diluted, the amount of polluting entering the waters versus the amount that leaves the point source, the manner of the area by which the pollutant ever enters the navigable waters, and the degree to which the pollutant at that point has maintained its specific identity. So here we sort of have principles that are more science-based: hydraulic conductivity, transmissivity, fate and transport mechanisms, things of that nature. So that's why it's a case-by-case basis. You have to look at all these different factors to determine whether a permit is actually required. Now, the EPA put forth some guidance on this matter. Guidance is not controlling, but you can further refine with the system design and performance. So this is going to be something that, as of right now, takes a little bit more science to define whether a permit is actually required. Now, just 2 days before the court put forth its opinion, the EPA put forth in the Federal Register the definition of waters of the United States. So they define those as the jurisdictional waters of the United States. And they said that those are territorial seas, interstate commerce waters, tributaries, lakes and ponds, and adjacent wetlands. The most important thing is that what the EPA said was not jurisdictional water is groundwater. So we have two competing things going on here. The EPA says one thing, but the court says the other. But stage right, enter the new presidential administration. President Biden has already vowed to have a flurry of executive orders that will probably roll back a lot of the environmental provisions that the previous administration had done. So now the question becomes, what's going to happen with the definition of waters of the United States? Is groundwater going to be considered one based on the functional equivalency test of Maui? And what's going to happen with that? So that's the first area of discussion that I had. The next up is something that's going to be hitting a little bit more close to home, and those are critical management areas, specifically Diamond Valley and what's going on right now in the courts with that area. So a brief history of CMAs. They were created by the legislature in 2011 with AB 419. This generally gives the state engineer the ability to designate a critical management area where withdrawals of groundwater had consistently exceeded the perennial yield. Now, this is codified in Nevada Revised Statutes 534.037, 534.110 sub 7. Now, there's a lot to read here. I'm not going to bore you or waste your time, but I want you to look at subsection 2, which has the enumerated provisions of A through G: hydrology, characteristics of the basin, geographic spacing of the wells, things along that nature, and any other factor deemed relevant by the state engineer. And all these, it's whether the state engineer can approve a groundwater management plan in a basin which is designated as a critical management area. Here's 534.110 sub 7, some rules and regulations for a CMA. The state engineer has a discretion under subsection 7 sub A to designate a CMA where groundwater withdrawals consistently exceed the perennial yield, but the state engineer is obligated to designate a basin as a CMA when a majority of the permit or certificate holders band together and say, we need a critical management area for our basin, and we're going to have a groundwater management plan. So to continue on, August 25th, 2015, state engineer promulgated Order 1264, designated Diamond Valley as a critical management area. This starts a 10-year clock where a groundwater management plan has to be approved, and it has to have some sign of showing that the CMA designation can be removed. In Diamond Valley, the users spent numerous years coming together, getting a plan in place, presenting it to the state engineer with help from multiple different people. And on January 11th, 2019, the state engineer promulgated Order 1302, approving of the Diamond Valley Groundwater Management Plan. Well, after that, some users decided to appeal it. But before that, they looked at the groundwater management plan overall and said, the plan itself converts the groundwater rights to shares. They're applicable only to irrigation rights or rights that had a base in irrigation, but they don't apply to the standalone mining, milling, dewatering rights, municipal rights, commercial rights, things of that nature. So it's only targeting irrigation. The shares are supposed to be reduced over a 35-year period. So there might be a little bit tension with the 10-year clock under the statute and the 35-year period, but there's some arguments that you just can't take a basin which has been depleted and fix it within 10 years. So there's a little bit of play there. Science probably reigns supreme on that one. And then also that shareholders can put their water rights into a bank and save them for a later year. So maybe rotation of crops and things of that nature. Groundwater management plan or 1302 were challenged by a couple of people who have some of the most senior groundwater rights in Diamond Valley. Their arguments generally was that there was no due process associated with the hearing. It's a contravention of the statute. It takes away from the prior appropriation doctrine, things of that nature. But the 7th Judicial District Court, in its April 2020 ruling, said that the public hearing afforded due process. The state engineer considered all the factors that were shown in subsection 7A through G, and the state engineer also has its authority to manage the Diamond Valley Basin, and the groundwater management plan does not violate the Aquifer Storage and Recovery Statute. So those are things that the court said the state engineer did correct. However, the court then went on to say what the state engineer didn't do correct. The groundwater management plan was a violation of the beneficial use. There was still an impairment of vested rights. It's a violation of the prior appropriation doctrine. And there was no legislative intent behind those two statutes to allow junior users the ability to dictate a senior user's right. And the court said that that was pretty unreasonable. And also that the groundwater management plan violated the change application statutes. So this decision was recently appealed to the Nevada Supreme Court. Briefing on that just ended last month, and oral arguments are coming up next. But what I'm going to present to you are the arguments of why the groundwater management plan presented to Diamond Valley is consistent with the actual statutes, and also arguments against why it's not. So the appellants were the state engineer and the Diamond Natural Resource Protection Conservation Association. They said that approving the groundwater management plan does not violate the beneficial use doctrine. The statutes actually authorize a departure of prior appropriation. There was the statutory intent or the legislative intent to avoid the harsh consequences associated with the strict adherence to the prior appropriation doctrine, namely being first in time, first in right. If a junior user is not getting its water, a senior user is not getting its water, a junior user must be cut off. Given the amount of junior appropriations in Diamond Valley and the perennial yield of 30,000 acre feet, there would be a pretty large amount of the junior users who would be cut off under strict adherence to prior appropriation doctrine. The factors associated with 534, 037 sub 2, A through G are a substitution that the legislature created to steer clear of the prior appropriation doctrine. And considering those, the groundwater management plan should be sufficient because the court below found that the state engineer considered all those factors. The appellants here also argued that the court's interpretation violates statutory construction. With the court's interpretation, the statute itself is rendered meaningless. Therefore, there's no way for the statute to have any teeth if we adhere to what the 7th Judicial District Court ruled. There was also instances previously of a deviation from the prior appropriation doctrine. And the court's ruling also divested the state engineer from the implied powers given by the legislature. And also there were some after the fact events that the court looked to, which was improper. Further, the groundwater management plan does not impair any vested rights. And there was an issue of whether the junior users actually depleted spring flow. There are other court cases saying they did, but in this particular court case, that was not in the administrative record, therefore it should not be considered. The groundwater management plan will actually improve the aquifer, and so there's not going to be any continued harm to vested rights. And there's the 35-year time frame. That's not going to hurt vested rights either. And the court's ultimate finding attacks the legality of the statute. So the state engineer still maintains the ability to manage the basin based on the change applications and the terms of the actual groundwater management plan itself. One of the interesting arguments is that the legislature can modify the prior appropriation system, particularly for groundwater rights. groundwater rights were created under the statute in 1939, and it wasn't a common law aspect, kind of like how surface water was. So because the legislature created the statutes for groundwater rights, then it has the ability to change those, specifically for the police power to protect the public. Like I said, there are a lot of junior users, and a strict adherence to prior appropriation would definitely cut back a lot of people on their water. And furthermore, there needs to be that police power to protect groundwater dependent communities. The people in Diamond Valley are certainly one of those. Now, the respondents here, the Sadler-Renner, as well as Bailey, have the other end of the arguments, basically. They say that the groundwater management plan violates prior appropriation doctrine because it's specifically cutting back senior water rights, which is totally against what prior appropriation stands for. It also violates beneficial use. The statute does not allow the creation of a new water law. And they also said that a majority vote is the incorrect standard. Given the vast amount of junior users, there's already a large amount of people who would clearly vote for something that contravenes prior appropriation doctrine. On the other side of that, both DNR PCA and the state engineer said that there were some senior users who did vote in favor of the groundwater management plan. Another big issue is that the opponents of the groundwater management plan says that the basin, even after the 35-year period, will not adhere to the perennial yield. There's still going to be 150% of that 30,000 perennial yield that will be pumped. So that could be an issue. But the opponents also said that the groundwater management plan was not based on substantial evidence, and that adhering to the groundwater management plan would be a taking of somebody's property right. So there's a lot of issues that the Supreme Court has to figure out right now. Whether these two statutes are allowed to sort of contravene the prior appropriation doctrine, to what extent. So it's going to be really interesting to see what happens going forward with this. And there are a couple areas in Nevada where CMAs could be created. In a recent case with the Humboldt River, which was dismissed, there was the talk that all the basins within the Humboldt River should be designated CMAs so that the whole collective unit would have to come together and create a groundwater management plan. There's also the Walker River, which Laura will discuss shortly. Lower White River Flow System, the Order 1303 basins. How's that going to work out? And then any other designated basin within the state. Will pumping consistently exceed the perennial yield? And what's going to happen with that? So here we have two things that are in flux: critical management areas, as well as waters of the United States. Only time will tell what happens. But speaking of flux, I'm going to change things over to Laura right now. Thanks for having me, and take care.